I wish the Babylon Bee the Babylon Bee should write a counter brief. That would be really funny, where the Babylon Bee writes a counter brief, but it's so insane that it ends up supporting the Onion's brief. God, they need to do that. Babylon Bee, this is my plea to the Babylon Bee. I don't know if you know who I am, but I love you and I respect you. Please write a parody counter brief to the Onion's brief in this case that is so absurd and so ridiculous and funny that it actually supports the position of the Onion and Mr. Novak. Because that is the correct position. It is the correct position. But I feel like you guys have the chops to outright the Onion on this. Because your parody has been better than the Onion's for years and years and years. Please do it. Please. I don't know how to contact you. I don't know if you've ever seen my show. But I think it would be really, really tremendous. Okay, so they actually wrote briefs on both sides of this issue. Let's read the fake one first, because the real one actually references the fake one. Let's do it that way. So here we go. This is Supreme Court of the United States, Anthony Novak versus City of Parma, Ohio. This is their brief in support of respondents. This is their brief in support of the city. This is what I suggested that they do. So here's their table of authorities. They list all their citations, which is great. And then their statutes, other authorities. Adolf Hitler's Mein Kampf. Benito Mussolini has revealed in his political speeches. Oh no, CNN's Brian Stetler. The Onion is a great parody site, but the Babylon Bee is straight up fake news. Joseph Stalin, the collected works. And Mao, the Great Leap Forward. Okay, their citations are already on point. Let's check it out. So the interest of the amicus curiae. So here's how amicus briefs works. You have to write why you are an interested party. You're not a party to the lawsuit, so you're not legally interested, but you may have some tangential interest, right? Like the outcome of this lawsuit could affect you in some other way. And so you write an amicus brief to say, hey, this issue is important to me, not the particular party. I mean, everybody writes it in support of a party, but they're presumably interested in the issue. And yes, Phil McCracken is in there as well. Philip McCracken, Humor in America, a source book. And we got Tyler Huckabee. The Babylon Bee is refusing to delete the posts that got their account locked on Twitter. All right. The Babylon Bee is the world's most popular news site, bringing deadly serious, 100% accurate stories to the public's attention since 2016. The Bee has inspired many imitators, such as the Borowitz Report, Mad Magazine, and a rival news organization that unfortunately filed in support of the petitioner in this case, The Onion, often described as a less popular secular knockoff of the Babylon Bee. Since its inception 6 years ago, the Babylon Bee has been cited in congressional hearings, tweeted out by the once and future president of the United States, Donald Trump, based, and shared by millions of confused grandmothers on Facebook. The Bee receives tens of millions of visits every month, boasts millions of followers on popular social media sites like Facebook and Twitter, and also Truth Social, and has published over 10,000 articles containing a total of no fewer than 2 jokes. Yet, the Babylon Bee has faced tremendous opposition in its brief life. The site's account was unceremoniously banned from Twitter merely for honoring a public official with a prestigious award. So, number one, no counsel for any party authored this brief in whole or in part, and no individual or entity other than the Babylon Bee and its counsel made any monetary contribution intended to fund the preparation or submission of this brief. Timely notice of intent to submit this brief has been provided as required, and all necessary consents have been obtained. So that's their citation on the interests of the amicus. So number 2 here. Ariel Zilbert, Twitter suspends Babylon Bee for naming Rachel Levine Man of the Year. That's what got him suspended. They named Rachel Levine Man of the Year. Fuck. CNN's Brian Stetler also called it fake news. Wait, what's their CNN's Brian Stetler, The Onion is a great parody site, but the Babylon Bee is straight up fake news. Okay, that's it. Just citation. Snopes has fact-checked dozens of its articles and incorrectly and libelously labeled them false, and thousands of liberals have left mean comments on its Facebook page. Thus, the Babylon Bee knows what it's like to have people to be mean to you. It files this brief in support of the respondents in this case, as it is the editorial staff's direct interest to make sure that people cannot make satirical or sarcastic critiques of, publish parody pages about, or post mean Facebook comments concerning the Babylon Bee, because it really hurt their feelings. All right, introduction and summary of the argument. So your next step after your amicus, or after your interest of the amicus, is you have to provide a summary of your argument. So this is legal writing, okay? It's called IRAC format, not Iraqi format, but IRAC, introduction, rule, argument, conclusion. That's how you write legal documents. And like, so the way an IRAC works out is you'll have an overarching IRAC and then mini ones for each subject, but basically this is it. You state your introduction, then you got the rule, then you got your argument, and then you've got your conclusion. So your introduction has the summary of the argument here. Then you'll flesh out your arguments in the body of the text. When the staff of the Babylon Bee were alerted to the pendency of this case, they immediately realized the importance of filing a brief in support of the Parma Police Department and City of Parma. It is essential to protect those with coercive power who wield it for self-preserving ends. Plus, the Babylon Bee just really likes police officers, what with their badges and guns and stuff. They're so cool. Moreover, deeper philosophical and constitutional issues are also at stake. First, abuse of the First Amendment should not be tolerated. The petitioner seeks to turn that provision into a living amendment stretched beyond its original meaning to include humor and laughter. This is dangerous, as it is clear from a close reading of the Constitution that laughter is never explicitly mentioned, and that is a slippery slope we do not want to slide down. Who knows what other kinds of speech might eventually be protected by the Bill of Rights? Speech from people we disagree with? Second, our society can only function if people get their information from a tightly controlled source that has never lied to us, like the government or the police. Then they can know it's 100% accurate. Petitioner's case threatens this status quo. God, I wish they would have filed this one, frankly. Third, the feelings of those who are being made fun of are rarely considered in free speech cases like this one. In other words, when assessing whether particular speech is protected by the First Amendment, courts must also consider whether that speech hurts someone's feelings. Fourth, it is impossible for us to function as citizens and humans if we suspect someone might be snickering at us behind our backs. That individuals might be allowed to use frivolous lawsuits to harass those who protect society from this sort of collapse is too much to bear. Argument: when the First Amendment was written, jokes hadn't been invented yet. Okay. The petitioner in this case, Anthony Novak, appeals to the First Amendment, but this argument does not hold water, for the Founding Fathers never intended for the First Amendment to protect jokes. Because jokes had not been invented yet, citing Fulton versus the City of Philadelphia, quote, courts must determine original public meaning of the Constitution. Historians mostly agree that the first joke was told by Bob Joke of Toledo, Ohio in 1927, well over a decade after the Constitution was written. It was, a copper walks into a speakeasy and the bartender says, "Get your own giggle water, kiddo." Its meaning has been lost to the ages. Clearly then, unless James Madison had a time machine, the framers of the Constitution only ever intended the First Amendment to cover serious talk and not jokes. See Philip McCracken, Humor in America, a source book. Madison was thinking the First Amendment would cover speech that existed in his day, such as "Tally ho, old boy, fetch me that powdered wig," and "The Johnson farmstead acquired 3 new chickens last fortnight," citing Marbury versus Madison. He was not thinking of parody pages of local police departments, memes featuring pictures of minions, or jokes about the relative size and obesity problems of your mother. That is, of course, not to even mention that the internet itself hadn't been invented yet. Al Gore wasn't even born until 1948. In short, The First Amendment cannot cover Mr. Novak's disparaging parody of the fine, upstanding police officers in this case because he did not write it with quill and ink by the light of a lamp fueled by whale oil, much as how the Second Amendment was only intended to protect the citizenry's right to bear muzzle-loading muskets and not fully semi-automatic 30 magazine clip assault pistol grip firearms. So the First Amendment cannot be applied to parody Facebook pages. See District of Columbia versus Heller. Parody is bad because it can make people doubt trusted institutions such as the government. One aim of parody is to mock ideas the satirist disagrees with, which is great when parody is pointed at acceptable targets such as people we ourselves disagree with. But when this dangerous weapon of free speech is pointed towards official trusted state sources, it becomes a deadly cannon of fascism aimed right at the heart of our democratic norms. Throughout history, we find examples of the powerless speaking out against the powerful, and every time we find the people who spoke out were on the wrong side of history. The powerful are always right. If they weren't right all the time, they would never be able to achieve such power. That's just science. See Mao Zedong, The Great Leap Forward. Think how much more effective the government could be if we banned comedy. Police officers could do whatever they wanted. Bureaucrats could rule with impunity. Presidents could get away with murder. Well, more than they already get away with anyway. It's really annoying and inefficient for the government when comedians are running around criticizing them. It can ruin their whole day. 3, when satire criticizes those in power, it makes them sad. We ask the court now to recall the fable of the emperor with no clothes, the insensitive, unruly child with no filter, and a strong belief in the First Amendment shouted out for all to hear. Hey, look at that dummy who's not wearing any clothes. See Carrier versus Kaminko, Alaska Inc. They cited a court case that references the emperor. Of course, the story is supposed to teach us that we must make a brave stand for the truth and that unpopular speech is sometimes correct. But no one ever thinks about how sad it made the emperor. Everyone praises the little boy for his darling and truthful statement, but nobody considers that the emperor might have been leaning back in a chair, turned to the side, and it might be distorted. Wait, might not have enjoyed being made fun of. I read that wrong. Imagine being up there all naked and whatnot, and everyone starts pointing and laughing at you, shouting things like, check out that dude's massive gut. Imagine that happening. I can't. And nice farmer's tan, and were you in the pool or something? Just not cool on any level. The court must consider the disastrous effect satire can have on the self-esteem of those who run trusted institutions. Studies show that people with low self-esteem have a harder time running everything and telling everyone what to do, and that's citing Joseph Stalin's collected works. This would be an unmitigated disaster for our society. Have you ever seen how sad Joe Biden looks? That's because lots of people on Twitter make fun of him. Thus, this shows that satire and parody are unacceptable in the current year because they make people sad. We can never truly enjoy our freedom since, as Americans, if we know that someone somewhere might be making fun of us, this is true. This is true. The petitioner in this case wants us to believe that free speech is more important than the police officer's freedom from having someone make fun of them. They want us to believe that the right to tell jokes is more important than a police department not looking foolish in front of the entire community. This is dangerous argument, probably shared by Hitler. Cites Mein Kampf. Okay. Freedom requires public safety. And when the public safety is threatened by the sadness of an authority figure, stopping people from telling jokes becomes a literal matter of life and death. As we all know, the use of government power that saves even just one life is always worth it and will never backfire in any way. History clearly shows us this, citing but all of history. Oh shit. Here's the Adolf Hitler quote. Ich aufgenommen Strudel unser Gebüsch. Nine. If making fun of police officer can threaten public safety, we ask the court to consider the utter carnage that can be inflicted on the citizens of this country if unregulated comedians were free to make fun of anyone and anything at any time. The knowledge that someone somewhere out there is making fun of you is an existential threat to one's mental health, and by extension, a threat to the health of the entire country. How can we be free to pursue happiness if we become the butt of a cruel joke? Conclusion: in short, parody must be eliminated, and humorists should be rounded up into camps and shot, citing Benito Mussolini. It is blood which moves the wheels of history. It's worth it if it saves just one person from getting laughed at. So there we go. Do you believe all this stuff? You are not smart. The police's arguments are lame. To see what we really think, read the brief we actually filed, at the Supreme Court, which is right here. This is the brief they actually filed. I thought they should have filed that one, though. Honestly, I really think they should have. I think it was fantastic. I think it was perfect. Now I've got the actual brief. Babylon Bee is a dangerous, citing Libby Emmons. CNN reporter claims Babylon Bee is dangerous. From the Post Millennial. Far-right misinformation site, citing New York Times, far-right misinformation site, the Babylon Bee uses satire claim to protect its presence on Facebook. Imagine the unmitigated audacity of the New York Times to be like this is fucking irritating. Far-right misinformation site, the Babylon Bee uses satire claim to protect its presence on Facebook. Fuck you. But when its writers are up for a more of a challenge, occasionally uses satire to draw on and reinforce actual misinformation and conspiracy, citing oh shit, oh damn it. I missed this line that typically peddles fake news. That's citing Brian Stelter. And then here we go. This one is citing Parker J. Bach. Can the right make good satire without collapsing due to fake news? The Bee is part of the conservative media ecosystem famed for its conspiratorialism and questionable reporting. Citing, again, Parker J. Bach from Slate. These people write so many articles about the Babylon Bee, and it's been an open parody site and satire site forever. The Bee has had some success with the whole satire thing, with 20 million page views per month on its website, citing James Varney, the Babylon Bee, satire real news from the Washington Times. The Bee is quite possibly the most popular source for satire in the history of the world. The Bee has inspired many imitators, including our fellow amicus curiae in this case, a cute little upstart known as the Onion. Like Mr. Novak, the Bee is frequently the target of censorship and attacks from powerful people who don't get, or at least don't appreciate, its jokes. The Bee has faced the ire of a diverse group of establishment media types, including the New York Times, Washington Post, and CNN, and the wrath of massive tech companies who functionally control the lion's share of public debate in our society. As a matter of fact, the Bee is serving a brutal life sentence in Twitter jail as we speak. R.I.P. to the Babylon Bee. Ariel Zilber, Twitter suspends Babylon Bee for naming Rachel Levine Man of the Year. And the Babylon Bee is refusing to delete the posts that got their account locked on Twitter. Its writers would very much like to avoid a consecutive sentence in a government-run facility. Summary of the argument: truth is stranger than fiction, and fiction is illegal, at least in the Sixth Circuit. That court's decision depriving petitioner Anthony Novak of any opportunity to hold accountable those who searched his home, arrested him, and jailed him because the parody he wrote was too effective should be reviewed by this court on the merits. That's a good fucking paragraph. Props on that one. That is real. That's just good legal writing right there. First, parody plays an invaluable role in a free society. When parody is imperiled, citizens are deprived of one of their most effective means of criticizing the government. Another good one. Second, the Sixth Circuit's ruling will allow the state to punish vast swaths of speech erstwhile protected by the First Amendment. The Bee and its writers could be held criminally liable for many, if not most, of the articles the Bee publishes. Good grief, the Bee could even be on the hook for publishing this brief's doppelganger, which we just read. Third, the prospect that an individual or entity charged with a speech crime might ultimately be vindicated at a criminal trial does little, if anything, to temper the speech-chilling effects of the decision below. Okay, what they're talking about here, and this is a really, really important aspect of First Amendment protections, that is one of the good things the Supreme Court has done. So the argument is, well, we can arrest them if we have cause. And then, of course, their good name will be cleared, once we have a trial and they've gone through it. But the process is the punishment. Indict them, label them a criminal, tell the community that they're criminals, tell their employers that they're criminals, make them take time off of work, make them miss meetings, make them miss church, make them go in, put them in chains, put them in a cell, do all of the things that we do to criminals all the time. But I mean, they'll get out of it in the end. So the Supreme Court said the government can take certain actions that, while those don't directly violate the First Amendment in a legal sense because they don't ultimately result in a government punishment, they said, well, we need to protect against this thing called a chilling effect. Because if someone wants to say something, but there's a prospect that they might get arrested for it, then they just won't say it. And that infringes on the free speech rights of the person who would have otherwise said it if they knew they had the freedom to do so. Extremely important First Amendment principle there. The Sixth Circuit's qualified immunity on steroids approach means that state actors can search, arrest, jail, and prosecute offenders like Mr. Novak without fear of ever being held to account themselves. And again, that's what happened in this case. This guy was prosecuted. He won. He's not guilty. Now he wants to go after the government for infringing his rights and causing him harm. Even though he didn't go to prison for it, he was harmed. And he has every right to pursue that. It's a USC, I can't remember the main thing, but it's a 1983 claim. Knowledge that they may be searched, arrested, jailed, and prosecuted without recourse is enough to dissuade most would-be speakers, regardless of the potential for ultimate acquittal. And so then they cite their brief, Babylon Bee, as amicus curiae for respondents. See also the inevitable confused internet commentary that will follow. Argument: parody is essential to a free society. The Onion may be staffed by socialist wackos, but in their brief defending parody to this court, they hit it out of the park. Parody has a unique capacity to speak truth to power and to cut its subjects down to size. Its continued protection of the First Amendment is crucial to preserving the right of citizens to effectively criticize the government. Furthermore, parody shouldn't be stripped of constitutional protection just because it's not clearly labeled as parody. And requiring that parody be written so as to ensure that the most gullible in our society, the Facebook-using grandmother, the tween TikTok addict, the CNN reporter, don't take it seriously, ruins the parody for everyone else. The Sixth Circuit's decision undermines those fundamental principles, and this court should grant Mr. Novak's request for a writ of cert in order to right the free speech ship. The Sixth Circuit's ruling allows the government to punish vast swaths of constitutionally protected speech. Police, the Sixth Circuit has previously said, cannot punish a peaceful speaker as an easy alternative to dealing with a lawless crowd that is offended by what the speaker has to say, citing Bible Believers versus Wayne County. But that same court's ruling in this case means that police can punish a peaceful speaker if they are the ones offended. Critical distinction. In the original case, some people were out speaking some inflammatory Christianity, right? These fucking sodomites or whatever they said was probably golden, but they're out there criticizing somebody and it offended a crowd. And instead of going against the unlawful actions of the crowd, the police arrested the speaker for the crowd's reaction to the speaker. And the Sixth Circuit said that's not the way it's supposed to go. But in this case, the crowd is the police who are given the arrest power, which just means that the mob was given the tools and the weapons to fight against the unpopular speaker. Ohio Revised Code Section 2909.04b makes it a felony to 1, knowingly, 2, use any computer, other electronic device, or the internet, 3, so as to disrupt, interrupt, or impair the functions of any police, fire, educational, commercial, or governmental operations. This is way overbroad. Way overbroad. This should not be a law, period. This should have been struck down a long time ago because this scoops up tons of otherwise protected activity. You can't use any computer, electronic device, or the internet so as to disrupt, interrupt, or impair the functions of a police officer. It's a felony. How far does that go? How far does that go? In Mr. Novak's case, the Parma PD, backed by the city law director, a magistrate, and a municipal court judge, concluded that by creating his Facebook page, parodying the Parma Police Department, Mr. Novak had violated, or probably had violated, that statute. Therefore, the police reasoned he at minimum deserved search, arrest, jail time, and criminal prosecution. The Sixth Circuit didn't disagree, concluding that the police came close enough to getting it right to entitle them to qualified immunity. Qualified immunity is a routine pox on society. That is, respondents, quote, reasonably found probable cause in an unsettled case judges can debate. The Sixth Circuit reasoned that, one, officers were permitted to rely on inferences to establish the knowledge element. Two, no one contests that Novak used a computer and the internet to create his page. And three, the officers could reasonably believe that the calls to the department alerting it to the parody page's existence constituted a disruption. Voila, probable cause, or at least close enough to probable cause to justify a few nights in jail. Holy shit. You wrote a Facebook page, made some jokes, jail. Left in the hands of the Sixth Circuit and the Parma PD and other like-minded law enforcement, the speech-stifling Ohio statute used to go after Mr. Novak empowers state officials to search, arrest, jail, and prosecute parodists without fear of ever being held accountable. The upshot for the B is that, in Ohio at least, its writers could be jailed for many, if not most, of the articles the B publishes, provided that someone contacted law enforcement or another entity protected by 2909.04B to tell them that the articles exist. Yeah, because remember that other element is, well, someone called us. Oh, well, I mean, if someone called you, if someone called the police, then I guess that means we got to arrest the guy, right? Automatically. So someone called. What are we supposed to do? Take a simple example. Last March, a headline from the Bee trumpeted, donut sales surge as police departments refunded. Funny stuff. But suppose anyone had called the Parma Police Department to let them know that the Bee had published the article. In Ohio, the Bee could have been charged with a felony, its offices searched, and its writers arrested and jailed for days, all without consequence for the parties doing the charging, arresting, jailing, and searching. And what if Officer Riley's or Officer Connor's passive-aggressive brother-in-law had forwarded the article to one of them at his official police email address, and heaven forbid, Officer Riley or Officer Connor then had opened the email and read the headline while on the clock, thus interrupting his workday? Same result, a search, arrest, and felony charge for the Bee. And the sad thing is, they're not exaggerating. They're not exaggerating what could happen, because that is what happens when speech is stifled in any capacity. As with other news organizations of similar caliber and eminence, local police are a regular focus of the Bee's hard-hitting journalism, e.g. cop on laptop protecting community from drivers on cell phones, and police keep Antifa away from statues by taping job applications onto them. Okay, that was good. And then Uvalde police criticize Indiana mall armed citizen for not waiting around outside for an hour. Holy fuck. Whoa. That Uvalde headline hit fucking home. Didn't they? Holy shit. But their federal counterparts star even more frequently in the Bee's digital pages. It was the Bee, after all, that first reported on these recent antics at the FBI. FBI storms convent to arrest group of dangerous pro-life extremists, and FBI gets great night's sleep after raiding My Pillow guy. Okay, so this one is the Babylon Bee. The article, the two different articles are the citation there. But the Bee would be safe from the wrath of Parma's finest and their ilk in these circumstances. right? Since the FBI is a federal agency and not an agency of Ohio or one of its subdivisions? Wrong. The Ohio statute makes no distinction. Thus, had a caller contacted the FBI field office in Cleveland or Cincinnati to inquire about one of those stories or to express outrage over the suspicious timing of the FBI's raid on Melania Trump's Mar-a-Lago closet and the Attorney General Garland's acquisition of a haute couture wardrobe, 13C, the FBI raid on Melania's closet was justified, says Merrick Garland wearing gorgeous new evening gown and sun hat. The B would have been subject to a felony charge and right or jail time under the Ohio statute for disrupting, interrupting, or impairing governmental operations. Damn. And there could hardly be a more open and shut case for the enforcers of law and order in Ohio than that of a story from the B reporting on testimony before the House's January 6th committee. I thought I was going to die, says Capitol Police officer who held door open for protesters on January 6th. The Babylon Bee is out here doing the fucking work. So the two citations on this page are just bare citations to the articles. The article concluded with this self-incriminating line. The FBI has issued a warrant for the man who called the officer a cupcake and is asking anyone with information to call Nancy Pelosi's office immediately. That story is, by the Sixth Circuit's lights, dripping with probable cause. After all, the article explicitly asked readers to play their part in disrupting, interrupting, or impairing governmental operations by calling the Speaker of the House and thereby momentarily inconveniencing one of her staff members. All this is only the tip of the iceberg, as the statute criminalizes not only disruption, interruption, or impairment of police or government operations, but also disruption, interruption, or impairment of fire, educational, or commercial operations as well. Thus, the Bee and its writers could be variously subjected to search, arrest, jail, and prosecution for the publication of hundreds of articles unrelated to policing or other government operations. Consider college athlete surprised to learn his school has classes. Had a reader called the Office of Academic Affairs at The Ohio State University about the article, that would have been enough for law enforcement without fear of being held to account themselves to arrest the Bee's staff for disruption of educational operations. Likewise, with articles like, with the articles, Aaron Judge sets record for most home runs by person with a normal-sized head, and Subway begins promotional offer where they will use real meat for a limited time. Had someone contacted the Guardians or Reds about the former or an Akron Subway franchise about the latter, then it's goodbye freedom for the team at the B. Per the decision below, Parma's boys in blue could reasonably find probable cause at that point, and therefore search, arrest, charge, and jail with impunity. In short, vast amounts of protected speech are swept up in this criminal prohibition of alarming breadth, citing U.S. versus Hernandez-Cavillo, quoting U.S. versus Stevens. When local police and federal appellate courts, officials both high and petty, join forces to execute and then condone the search, arrest, jailing, and prosecution of parodists for protected speech, the very core of the First Amendment is rendered a dead letter. That's West Virginia State Board of Education versus Barnett. So now we're on to qualified immunity specifically. Where qualified immunity deprives a speaker of civil remedy, acquittal for a criminal speech charge is cold comfort. Mr. Novak ultimately was acquitted of the felony charge leveled against him, and the B hopes that when its turn comes to face the Committee of Public Safety in Ohio, the result might be the same. But this court should not confuse acquittal in circumstances like these with vindication of the robust free speech rights enshrined in the First Amendment. This goes to the most troubling aspect of the Sixth Circuit's decision. Certain passages of that opinion give the impression that the court's sympathies lie with free speech. The court, for example, this is good argument, by the way, because they're going to set up where the court covered its ass on speech. Oh, no, we sympathize with the speaker, and we're really glad that he didn't get arrested, right? They're going to do that, but then they're going to knock it the fuck down. Court, for example, purports to regret that neither the police officers nor any of the other state officials involved ever put the brakes on the search or the arrest or the jail time or the criminal trial brought upon Mr. Nova. Man, we just wish somebody would have stopped them. Maybe they should have stopped themselves. That would have been the ideal. If they just had stopped themselves, everything would be okay. But the aggressive form of qualified immunity the Sixth Circuit adopted, in fact, gives state officials a blank check to continue suppressing speech via these same means. The court had its doubts about the rectitude of respondents' actions, yet it chose to shield them from liability anyway. The Sixth Circuit purported to leave the parties in a state of relative parity. At the end of the day, the court opined, neither side got all they wanted. Fuck the government. It doesn't get to get what it wants. It only gets to get what it is empowered to get by our rights given to it under the Constitution. Little did Anthony Novak know that he'd wind up a defendant in court. So too for the officers who arrested him. Oh, it's the same, isn't it? It's the same being a criminal defendant and then being a civil defendant where you're not actually on the hook, but your department is. Absolutely identical. Disgusting. But in fact, the contrast between the parties' positions could hardly be starker. The Sixth Circuit's decision allowed respondents to deal a fell blow to Mr. Novak's First Amendment right to criticize the government while at the same time leaving Mr. Novak without any means of redressing this grievous constitutional violation. True, both Mr. Novak and respondents were, as the court's opinion says, defendants at one time or another, but Mr. Novak was a criminal defendant subjected to the ordeal of a criminal trial, including the fear of imprisonment, the public humiliation, and the financial strain that entails, citing Currier versus Virginia. And he was not just any criminal defendant. He was a criminal defendant and search subject and arrestee and jail inmate who hadn't done anything wrong. Yet he escaped criminal liability only because a jury adjudged him not guilty. Respondents, by contrast, were mere civil defendants, and even though they had violated his First Amendment rights, still they were afforded the luxury of avoiding trial altogether. They got a pretrial dismissal for qualified immunity. And the court acted like this is the same thing. Moreover, though they lost Mr. Novak's criminal case, respondents still managed to get what they wanted: thorough and efficient suppression of Mr. Novak's speech criticizing the police department. They intimidated Mr. Novak into removing his Facebook page, and then, by arresting him, searching his apartment, jailing him for 4 days, and foisting a criminal trial upon him, made it all but certain that he and anyone else paying attention would never commit a similar speech crime again. And this is what cops do often. Do not capitulate on this without talking to a fucking attorney. But they'll do this. Hey, we're going to really need you to delete that post. Look, it's just a good idea if you delete that post. You know, it'd probably go a lot better for you. Cops will say it all the time. It'll probably go better for you if you just go ahead and delete that, just delete it for now. Let's take it down. You can talk to, we'll kind of see what's going on. Take it. No, do not fucking delete your speech because a police officer asked you to. They're not your lawyer. They cannot give you legal advice. In the eyes of a jury, you may be admitting that you've done something that you didn't do when that comes up later. Do not do it. That is intimidation. That is a violation of your First Amendment rights as far as I'm concerned. And I've represented people who've been bullied by a police officer to take down what was fully protected speech. And guess what? That case got dismissed. There was never a crime. And the police officers knew it. Everybody fucking knew it. Don't delete anything. In my case, it was a kid who wrote a review on a hospital page. Kid, he was an adult, but about his dad, who's a surgeon at the hospital. Said he did all sorts of shit. Performed surgeries drunk. Shit he'd heard him do. Also told the real story. That this guy had abused him for years and years and years as a kid. And continued his abuse into the kid's adulthood. The dad contacted the police. No defamation action. Nothing like that. Contacted the police. And the police capitulated the fact that a prominent member in the community who worked for the hospital, which is the main employer, had written something bad on the hospital's review page. And the police threatened criminal charges, filed criminal charges. Now, how do you file criminal charges on that? Well, I'll tell you. In this case, there was a restraining order from the dad to the kid, which, by the way, was also not justified, but it was an ex parte restraining order, preventing communication with the dad. So the kid posted a review on the hospital's webpage, and the dad said that that was an improper contact in violation of the restraining order, and the police jumped at the opportunity to enforce the surgeon's will on the victim of domestic violence. Fuck the police. Never delete anything. The only means Mr. Novak had to counteract this throwing thoroughgoing suppression was to lodge an ex post civil suit against respondents in hope of holding them accountable. There was and is no other effective remedy available to him or the countless others whose federal constitutional rights are similarly abridged. But the Sixth Circuit closed that door to Mr. Novak, leaving him bereft of recourse. Quote, to an aggrieved party, a right without a remedy is doubtlessly not much better than no right at all. Citing Triad Associations versus Robinson. Great line. Great line that happens all too often. Qualified immunity is fucking garbage. The B has no reason to believe that the result would be any different should Ohio authorities choose to bring parody in violation of 2909.04B charges against it or any of its writers. Sure, if the B were to roll the dice with the jury, sanity might prevail. That is by no means assured. And even if criminal trial victory were in the bag without a means of dissuading state actors from continuing to arrest and jail speakers they don't like, any such victory really would just be a less extreme loss. The writers at the B are a hardy bunch, accustomed to regularly and brilliantly absorbing blows from powerful, prestigious media outlets, and also from CNN that desperately want to muzzle the B. Child's play. But whining establishment types who are unable to take a joke and who possess the coercive power of the state are an entirely different matter. Add to that mix the aggressive, unbridled strain of qualified immunity propagated by the Sixth Amendment, it's enough to make Chuck Norris sweat. See, Chuck Norris comes out of the closet as even more of a man. Conclusion, the Babylon Bee respectfully asks this court to grant Mr. Novak's petition for a writ of cert. And there we go. Frankly, tremendous effort. Very to the point, very short, very, very brief. They fucking nailed it. They nailed the legal points. They nailed the critical arguments. It's not overly frivolous. I think they should have filed the first one, but their second brief is very, very good. It's very, very good. Cheers to the Babylon Bee. Fantastic work, as always. And straight to the point. You know what I like that they did too? They really paid a nice deal of respect to the Onion when the Onion doesn't deserve any. Even though they did a good job, the Onion doesn't deserve any respect, and the Babylon Bee did. They said they fucking knocked it out of the park, and they're right. They're 100% right.
So pour out an odd bag of bow, more at Lafroig. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the love of